Thank you, Chairman Adler, for holding this important hearing. Professor Turley, I'd like to follow up on Congressman McClintock's line of questioning and just walk through some standards and whether judges are involved. So I wanted to talk about the difference between the contents of, let's say, a document versus metadata. So if the Department of Justice wants to get the contents of an electronic letter that is on your home computer, they would need a warrant signed by a judge. Is that right?
That's correct.
If they want the contents of that same electronic letter stored on the cloud, they would still need a warrant signed by a judge. Is that right?
Right. If they get the content, but they can get metadata that can show a great.
No, I got it. Yeah. No, let's not confusing. If they want the content of that electronic letter on the cloud, they would need a warrant signed by a judge, right?
Yes.
Okay. Now let's talk about metadata. First of all, what is metadata?
Well, it is defined by one person as basically data about data. That is, metadata describes data, and that can also then give you information as to the senders, the identification, the subject. That's a lot of information.
Understood. Okay. Yeah. So let's say the Department of Justice wants to get metadata that they believe is stored on your home computer. They would need a warrant signed by a judge, right?
To get access to the computer, that's correct.
Okay. Now, if they want to get metadata stored on the cloud, they could simply send a subpoena and get that data without a warrant. Is that right?
Yeah, and in addition, they make companies like Mr. Bird's company essentially the unwilling participants in that type of disclosure. They're being essentially commandeered.
Thank you. Basic question here. Grand jury subpoenas, a grand jury subpoena for metadata. Is a judge involved in that process at all?
For a grand jury, grand juries can issue for document production at a standard lower than probable cause. Judges are supervising that procedure, but in most cases, these things are issued with very little review, and more importantly, grand jury subpoenas can come under the probable cause standard for document production.
Got it. So let's go back to this example where if you have metadata that happens to be stored on the cloud, there's no longer a warrant requirement. What if Congress simply put in a warrant requirement for metadata stored on the cloud? What's your sense of that proposal?
Well, you could do that because remember, the probable cause standard is not some huge standard. It's actually, as a criminal defense attorney, I can tell you, it's a pretty easy standard for the prosecution to meet, but you have to have clearly articulable facts for getting that type of information. I don't think that the world would come to a sudden stop in terms of prosecutions, but it would make this, you would change the grade a bit to make it a little more of a climb for prosecutors, because right now, this is similar to the false lantern approach in the East Coast when people would put a lantern to confuse people to think there was safe harbor and this was a lighthouse. So people go to the cloud thinking correctly that the cloud has lots of protection for their data, and it turns out it's a myth once you do that.
Thank you. Now, I am sensitive to the view that we don't want to sort of draw lines around certain groups of people and not others. I do note that the Constitution specifically talks about the free press. So journalists are in fact in a different category. And the Constitution also does put in just structurally separation of powers. And when you have one branch, executive branch, trying to intimidate, for example, Congress and seizing all sorts of information, that does pose problems. So my view is that we could, in fact, try to do something different. And Professor, I want to get your thoughts. What if the Department of Justice, when they're getting information on either journalists or members of Congress, they had to provide a notification, for example, to the Department of Justice Inspector General, just as a sort of a second check on exactly what they're doing? What do you think about that?
I think that'd be a great idea in terms of greater transparency, but I want to note that some aspects of this confuse me. You have three former and current attorneys general saying they were not aware of this program. That's not supposed to happen. Since the 1970s, either the attorney general or a designated high official is supposed to sign off on this. And so I don't know what happened there, but it's one of the first things I think this committee should try to find out about.
Thank you. And my last question is to Mr. Bird at Microsoft. This increase in these secrecy orders, do you know what the investigations are about? Could it be, for example, about child pornography or something else? Does the DOJ tell you what those investigations are about? And with that, I yield back.
We don't always know what the investigations are about, but we do know enough to know that in the vast majority of these cases, they are just routine investigations that are not about child abuse online or about national security issues, but they're just routine. And I do want to make one thing clear, because I may have contributed to this confusion. When we talk about a standard like the warrant standard, the probable cause standard for a warrant, yes, we have to get a warrant before we produce content. Email, for example, and just a subpoena is all that's necessary to get metadata from us. But what we're here talking about today is the secrecy order that accompanies that warrant or that subpoena. And it's there that we need a higher standard and actual findings of fact to establish that a secrecy order is truly necessary.
Gentleman yields
Thank
back.